Alrighty, friends, welcome back to another episode of Law Schoolers, and welcome back to another discussion on criminal procedure. In our previous episode, we were talking about warrants and also exceptions from warrants, and then consent. In other words, we were talking about how do you conduct a full search. Now we're going to be talking about how to conduct a full seizure, and most generally that's going to be in the form of arrest. So our next category of topics that we're going to be talking about is arrest. In this episode, we are going to be focusing on principles of arrest, and specifically we will determine whether or not something is a stop or if it's more, and if it's more then it's arrest. We'll talk about some arrest warrants and how they differ from search warrants, and then also police discretion when they make arrests. So with that in mind, let's go ahead and talk about the difference between a stop and arrest. Our case of point that gives this definition, this distinction, is going to be Bailey versus State. I want to give a little bit of a review. A stop is where the subject does not feel like they are free to leave. We talked about this in Mendenhall in a previous episode. And then also something else to review is that a Terry stop requires reasonable suspicion not only to make the stop, but reasonable suspicion of a weapon. So, what's the example of an arrest test? Because this is really where we get into some challenging terms between states, because each state defines arrest slightly differently. And so it's kind of hard to tell when you go from a stop into an arrest. Where does that distinction really come back? Well, here's one example. This is one example from Bailey. There's 4 elements. Again, you need to have probable cause, but besides probable cause, you need to consider the following factors, and that's going to be whether the officer has the intent to arrest, if the officer had real or pretend authority, if the subject is seized and detained, and if the subject understands the seizure to be an arrest. This is a pretty fact-based rule, and so ultimately you have a lot of other rules that develop as well. Some courts are going to look to other factors, such as how long is the detention actually happening for. Is it going to be a 20-minute detention? Is it a 60-minute detention? Is it going to be a longer detention? In Florida versus Royer, that's the case there regarding the amount of detention to determine whether or not that's an arrest. That I believe in that case it was a slightly longer detention, or maybe it was a shorter detention. In that case, it was not an arrest, just based off the time that the defendant was detained. The second factor that you can consider is how is the subject restrained? Are they using handcuffs? Handcuffs are not required to effectuate an arrest, but if you do have handcuffs, it is much more likely that you are arrested. Again, even if you are wearing handcuffs, it's not a guarantee that you're arrested there as well. But handcuffs generally mean that you are going to be considered under arrest. Third factor to consider is the location of the subject. Specifically, are they in the back of a police vehicle? Are they in the jailhouse? Are they on the side of the street? And then the fourth factor that we are going to consider primarily is going to be phrases that the police made to this subject, such as, "You're under arrest." And if the police say something like that, well, then it's going to be much more obvious that the defendant in that situation is going to be under an arrest. So that's how you really tell whether or not you have a stop or an arrest. A stop is the person just feeling not free to leave, and you need to have reasonable suspicion. But if you're going to conduct an arrest, you need probable cause, and you need to see whether or not you have probable cause by the time that you actually get to the arrest stage. If you still have reasonable suspicion and you make an arrest, well, then that is an improper arrest, and the officers might be held to some potential liability and based off of making a false arrest. And those are going to be the 4 factors that we end up considering primarily. Let's talk about an arrest warrant. Previously, we talked about search warrants. You still need probable cause. You need to state with particularity. The places to be searched needs to be signed by a neutral magistrate under oath. An arrest warrant is similar but different. Instead of talking about the places to be searched, you're going to talk about the people who are going to be seized. So, State versus Thomas has 4 specific factors about an arrest warrant. The first takeaway that we want from this is that an arrest warrant can happen in a public place. 4 takeaways from State versus Thomas. The first takeaway is that an arrest can happen in a public place regardless of whether or not there's a warrant. But you still need to have probable cause. Second takeaway from Thomas is that arrest warrants are sufficient to enter the home of the owner if the owner is the subject of the warrant and the officers have reason to believe that that owner is present. That's our second arrest rule. Our third arrest rule is that if the subject of the warrant is different from the homeowner, then there needs to be a search warrant in addition to the arrest warrant showing probable cause that the subject of the arrest warrant is present. You need to do that before you enter the home. If there is no search warrant, this is our 4th rule. If there is no search warrant, then there needs to be evidence of consent or evidence of an exigent circumstance to enter the home. And an exigent circumstance can be shown by either a fleeing subject or the potential for destruction of evidence. Again, this cannot be police created. So what were the facts of State versus Thomas that kind of makes this happen? Well, the officers approached the home. They were looking for Thomas. The Thomas was outside his home when the officers came. And the officers, Thomas then ran inside the home, and the officers followed and executed the arrest at that point. So what's the key facts in here? Well, Thomas was outside, and then Thomas began to flee. And then the officers did have an arrest warrant in this situation for Thomas, and it was Thomas's home. And it was clear that an arrest in this situation could be made. Let's talk about Commonwealth versus Molina. We have a couple. This is an example that is distinguishing from State versus Thomas. In Commonwealth versus Molina, the officer had probable cause for a search warrant, but they didn't end up obtaining a search warrant. The officer then went to the home of the subject, who answered the door, and upon seeing the officer, immediately attempted to close the door, and the officer attempted to make the arrest as the door was being closed. When there was some resistance by Molina, the officer entered the home, and that's where they found evidence of a crime and that Molina was committing in this situation. So how is this different from Thomas? Well, it's different from Thomas because Molina was in the doorway, and there was no arrest warrant. And for these reasons, Molina's arrest it's on the line, and it's ultimately going to be up to the judge to determine whether or not that was a lawful or unlawful arrest. Let's talk about police discretion in making arrests, because police oftentimes have the ability to say, hey, you're going to be under arrest, or say, hey, no, you're not underneath arrest. The traditional common law arrest power rules where the officer could make an arrest for any crime within their presence, but they need a warrant on probable cause. Excuse me, let me just restart this sentence just so that it makes sense. The traditional common law rule is that an officer could make an arrest for any crime that is committed within their presence. They don't need a warrant, and obviously, probable cause if you're witnessing the crime. But you do need a warrant based on probable cause for any felonies or for any crimes that are outside the officers, that are committed outside of the officer's presence. There is a study that we ended up reading for this class too. It was Lawrence Sherman and Richard Burke who wrote it. It was a study based off of the Minneapolis domestic violence experiment. This was a social study of the Minneapolis Police Department to see what was the best way to mitigate domestic violence. Domestic violence is typically the largest case where the police have most discretion about whether or not to do an arrest. Do you conduct an arrest, or do you separate the victim from the aggressor? And what's the best way to approach domestic violence? And that's what the study was primarily based off of. But there are three main ways that this study found that are used to prevent domestic violence. You can first either conduct an arrest, or second, you can send the primary aggressor away, or third, you can try and give advice and provide mediation for the parties. The giving advice and providing mediation was the primary method used before the study had actually occurred, and after the study concluded that arrests reduced the number of repeat offenders, then arrests tended to be the most common way of effectuating or preventing domestic violence. And so after the study, it kind of altered the way that common law viewed the arrest power. And so officers can, after this study really came out, officers could make arrests for misdemeanors, not only felonies, that were made outside of their presence. Okay, so that's everything as far as our principles for arrest go. We talked about the difference between the stop and arrest, the four factors there that we're going to primarily look, the length of detention, how they're restrained, the location of the detention, and then also any phrases made by the police. We talk about arrest warrants and how they differ from search warrants, what needs to happen, and the rules for arrest warrants. An arrest can happen in a public place regardless of the warrants, as long as you have probable cause. Arrest warrants for homeowners. If the arrest is for the subject is also the homeowner, well then the officer only needs to know that the homeowner is present in addition to having the warrant. If the subject of the warrant is not the homeowner, well then you have to have a search warrant plus the arrest warrant. And then if you don't have a search warrant, then there needs to be consent of the homeowner or an exigent circumstance to conduct the search as well. Talked about a couple of examples of how that worked, whether or not you're considered in a public place or not. And then we talked about police discretion in making arrests, which primarily occurs in domestic violence cases. But just when do you need an arrest warrant versus when do you not need an arrest warrant as far as that police discretion goes. That's everything. Thanks for listening. Have a good one, and I'll see you later. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is, if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.